Alright folks, Alex Woods here, vlogging to you from Redwood Legal. We're experts in civil litigation. We have had a lot of building disputes come through over the past few months, so I'm going to do a vlog that's going to just sort of highlight the key features of a building dispute and what it is, what steps it is that you need to take in order to address them and to properly prepare when it comes to issuing proceedings in a building dispute claim and obviously thereafter. So I'm talking about not massive building dispute claims, which may be more appropriate for the technology construction court, six-figure type claims, and also do be aware that with high value building disputes you need to take note of a special pre-action protocol which applies to those types of disputes. But in all probability, if you're watching this vlog, you're probably a residential domestic type building dispute or a low value dispute over works done in respect of an office, maybe such that it's not a heavy duty construction dispute, and therefore you won't need, for example, to issue your claim in the technology and construction courts. We're looking at most of the claims certainly that we've handled have been fast track claims of anywhere between £5,000 and £25,000. So that's going to be the target audience, if you like. Okay. So as a nice sort of friendly list here for sort of the various what shall I call them, idiosyncratic features that you find commonplace and constantly repeat themselves in all sorts of general building dispute cases. First thing to say is make absolutely sure that your opponent actually is able to meet any cost orders that are ultimately made against him in respect of those proceedings. All right. There are a lot of cowboy builders out there, not just cowboy builders, but companies that have got themselves into financial difficulties, and quite frankly it would be easier for them to fold the company, leave you as a creditor, probably getting very little in the way of costs after you've successfully sued them in insolvency. So you really do need to do your checks before you issue proceedings, because the mantra, as far as I'm concerned, in relation to civil litigation in the courts of England and Wales, is to be taking a commercial view of the matter before launching into the costly business of civil proceedings. Now, you should know, and I've had a raft of cases like this, that the English law is not very friendly to individuals where it comes to trying to get money out of a limited company. The whole point of incorporating yourself as a limited company is, as the word reveals, that you limit your liabilities. So now a lot of people, I see this in pleadings prepared by litigants in person, tend to throw in a bit of a kitchen sink, and they accuse their opponents of fraud and dishonesty and so on and so forth. Fraud is one of the ways in which you can get round that limited status and go after the individual directors personally, because that's obviously what you want to be able to do. It's far better to be able to go after an individual in legal proceedings than it is to go after a limited company, which can just basically fold and leave all the creditors high and dry. Actually proving fraud, it's a very high threshold. Even if they have been fraudulent, proving it is a time-intensive, costs-intensive exercise. And 9 times out of 10, a judge is probably not going to be convinced that they've tipped over into real and genuine fraud. For example, setting up a company purely for the purpose of it being a shell in order to evade and avoid liabilities, well, that would clearly fall into the category of fraud. But that, number one, kind of rarely happens. People are usually half genuine, at least, when they first start out setting up a company. But also, as I say, it's just notoriously difficult to prove that was, the intention. Let me just illustrate by reference to a recent case. We've been instructed by a Polish supplier of wooden windows, sash windows, and wooden doors to a UK builder. Yeah, and this builder basically ordered wooden doors and windows from the Polish business over a period of a year, and then there was a small issue with one of the orders. And the cowboy builder in the UK used that as an excuse, not only not to pay for that order, but not to pay for a whole raft of other orders and invoices that had been raised, and then did a vanishing act. We've researched this builder, of course, and it turns out that the individual has got 4 different companies, that his daughter seems to be the director and the shareholder of most of them. And he's cleverly been revolving these companies, rotating these companies, like, keeping plates in the air, doing one job with one company, another job with another company, letting the company actually be close to being automatically dissolved by Companies House, and then quickly, if he needs to, reactivating the company. And, one of them is called Wood Windows Doors Limited, one of them is called Wood Windows of London Limited, one is called Sash Windows of London, one is called Sash Windows London without the of. So it really does look as if over a period of time this particular defendant has been, gaming the system. But unfortunately, he's allowed to do that. There's no law that stops someone from setting up 4 different companies with slightly different names. You've actually got to, discharge really quite a heavy burden. So that would be an example of where on the face of it, it looks as if you've got a dodgy builder and you could get behind the limited company status. But I'm afraid in English law, it is something of an uphill struggle. Can be done, and we are pursuing this particular individual and trying to get behind the limited company status. But it's costing our client a lot more time and money than might otherwise be the case. Yeah. So, be warned. Make sure that it's an established company, and if you're going to allege fraud, make sure you've got to get legal advice really if you're going to bring an action for fraud. Now, also check to see if the building company is insured. Ask for the details of their professional indemnity insurance. Yeah, most construction companies should have some sort of insurance in place. Check that it's the right insurance. I had a case a year ago where the clients had run the claim themselves, but they'd used another law firm. That law firm had written to the building company's law firm and asked them to confirm that there was insurance, and that law firm took the instructions from its client, wrote back a letter saying yes, our clients have confirmed that there is insurance in place, and then the issue of insurance was forgotten about. Our client then dropped its lawyers, the opponent then dropped their lawyers. You got a litigant in person directly against the building company, and it transpired. We got instructed later on in quite an advanced stage of proceedings to help, and it transpired that the insurance didn't cover the professional negligence of the sort that was being complained about. This was a kitchen extension that had been badly done, a claim of £15,000. So that's the first thing. Make sure that is actually commercially viable to sue your opponent, because you don't want to end up with judgment against a liquidated company. Believe me, that's then a whole other headache, and ultimately you'd be unlikely to get anywhere near a decent percentage of the money that is owed to you. Right, here's another interesting area with building disputes. I often find, like if I'm representing the construction company, that the builder, he might have issued quite quickly. He's sort of done the works. He doesn't understand why the invoices haven't been paid. There may be stage payments, of course, and he feels that the client is just, blowing hot air and isn't really prepared to honour the debt. And then they often issue proceedings without really giving their opponent an opportunity to lay out their side of the story. You often find this. People don't take disputes seriously until it's kind of too late, until proceedings have been issued and they've had a claim form land on their mat. And now the danger with that is they might actually have had a genuine grievance. It's just that, they didn't bring it to light at an earlier stage. Now, once proceedings have been issued, it's quite an expensive business. You're burning money, and it's quite difficult, actually, if there is a genuine defence, to sort of hold the defendant to account for that failure. Unfortunately, you're unlikely to be able to find a judge. Certainly, you're unlikely to be able to do this inexpensively, to sort of like at an early stage of proceedings, to say, look, we gave them a chance to respond and they didn't, and now we've got this defence. So in a way, the onus is on you to really try and get your opponent to explain exactly why it is that they're not paying these invoices. Yeah. Now, that also raises another issue, and that's the issue of allocation. You may be thinking, as you're watching this vlog, I've got a claim of 10,000 odd. I want it to be a small claim so it doesn't balloon into a dispute involving costly lawyers. But unfortunately, having issued the claim, you're then confronted with not just a defence, but a counterclaim. Now, this is typically the case where, let's say you're the builder and you're suing the individual. They say that not only were the works badly done, but perhaps not completed, let's say, but also they've incurred costs from the damage that was done. They may have had to get another builder in to remedy your errors. Now, in that situation, you're facing a counterclaim, and it could clearly then make the claim a much bigger animal from the purposes of allocation. As I never tire of reminding people, we don't have a small claims court in this country. You can't elect to go into the small claims court just because your claim is under 10,000 at the point that you issue it. The court decides, and the court will be deciding off the back of not just your, let's say, £9,999 claim value on the claim form itself, but on the defence, on the dispute in the round. And if that counterclaim is 6, 7 or 8,000, you are looking at it being allocated to the fast track. So it's another good reason for really checking out the dispute and giving your opponent an opportunity to lay out their side of the case before you issue proceedings. In fact, in a way where building disputes are concerned, this is why there's a special pre-action protocol in relation to construction disputes. The courts want people to try and address all the issues prior to getting to court. Okay. Also be aware of a little small point in this, but it does come up, of double recovery. Now, let's say you are a consumer and you have been, let's say it was a £10,000 job, a claim, you've only paid half because the works were done badly. You've got a £5,000 outstanding bill, but this builder has cocked the job up. You've got other builders in, and the cost to you of remedying the works and completing the job is, let's say, £10,000. When you bring your claim in that little box, the claim value box on the N1, what figure should you be putting? Well, you shouldn't be putting 10,000. You should be putting 10,000 minus the 5,000 that you owe the builder, okay? So in fact your claim value is 5,000. I hope that makes sense and self-evident, but you'd be surprised when you get down to the nitty-gritty of a case and the complexities. This danger of double recovery does raise its ugly head, and it can get you in trouble because basically your claim is inaccurate, and you risk facing an application from your opponent which could be expensive, requiring you to amend your particulars of claim. Okay, now civil litigation, if about nothing else, is all about costs, yeah. And you have got to make sure that you don't run into a heavy cost bill because of the way that you've conducted proceedings. And even if you win, you may not get your full costs back, yeah. Unfortunately, it's a fact of life where civil proceedings are concerned that you'll often end up, if not at trial, certainly in settlement, having to take a hit on your costs, yeah. Now, costs are really important for the reason that, well, when it comes to offers, in short, they become very important, because when you pitch an offer on not just the claim value, but also you may be making an offer to your opponent on costs, you may be making a global offer that includes both your legal costs and your claim value. You want to know exactly what the precise value of the claim is, yeah. So you'll find it's very commonplace in building disputes, and I urge you to undertake this exercise before you issue proceedings, to produce what's called a Scots schedule. And that essentially is where you have a table and you pinpoint each and every issue. The kitchen wall was damaged by metal studding. The cladding around the boiler was half completed. The shower unit was not finished and the tiling was not grouted. There was damage during the course of building works caused by scaffolding poles to the woodwork in the hallway. An expensive door was damaged, a cost of £1,000. You need to list all of these, and time and time again, litigants in person go belt and braces on how negligent they've been, how dishonest they've been, often focus on irrelevant issues. For example, I've had a claim recently where the builder deliberately moved the electricity meter to accommodate the works. Now, that may be a criminal act to move an electricity meter without permission, but the key question is, what are your losses? Has it caused you any losses? And so you do need to focus on losses. Civil litigation is a system designed to compensate you for your losses, not to punish a cowboy builder for poor workmanship, okay, or emotional distress or anything of that nature. It could include lost rental incomes, and I'll come on to that at the end of the blog. So you need to produce this Scots schedule. Google Scots schedule. I'm sure you'll come up with samples online, but essentially you're just itemizing each area of damage, each issue, and in another column alongside the estimate of the repair job or the completion estimate for those particular items. You'll almost certainly, before you issue or shortly after you issue, want another builder to come in and price up the damage that's been caused and an estimate to complete each and every individual item. So this is quite a systematic business. This is one for the geeks, yeah, the construction and engineering and maths geeks, to break it down very clearly. Now, the reason why that's so important, I'll come on to offers now, is because the structure of civil litigation is what's sort of built into the structure in the civil procedure rules, which is the Bible on procedural law in the courts of England and Wales as far as civil litigation is concerned. What is built into the system is a means by which parties are encouraged to make low offers, very competitive offers early on, to try and avoid the financial burden, not just on themselves but on the overworked, badly clogged up legal system. Poor judges and their staff are underfunded and overworked, so the system is designed to encourage you to settle early. You will have heard something called CPR Part 36, a Part 36 offer. I've done a vlog on Part 36, so have a look at that. It's a mechanism which encourages you to make offers really quite early on to protect yourself from having to pay a big cost bill, win or lose, at the end of the claim. Now, the one thing, I won't talk to you about Part 36 here, but the one thing that you do need to focus on is calibrating your Part 36 offer just right. And you can't calibrate it just right unless you've done the exercise on the Scott schedule, you've got another builder or an expert even to come in and to price up the damages that have been done and the costs to remedy them. Right, that brings me on to experts. Experts, bread and butter in building disputes. You will invariably find yourself in front of a judge and he'll say, oh, I don't know whether the work was done badly or not. I don't know anything about building. I'm ordering you to jointly appoint an expert with your opponent and for them to come in and to report by a certain day, for you to then write follow-up questions by a certain day, for then him to finalise his report by a certain day, da-di-da-di-da-di-da. So there'll be quite prescriptive orders. This is after you've filed your statements of case, after it's been allocated, or at the point of allocation this order will come out giving directions as to how you should go about getting an expert in to give his view on both whether the works have been done negligently and the costs to complete them. The claimant usually, it's his job to furnish his opponent with 3 independent experts and invite the defendant to choose one, and you'll both have to halve the costs of that. Question arises, doesn't it, whether you should get your own expert, and whether you should get your own expert quite early on during the course of proceedings. Well, in a low value dispute, it's probably just not financially sensible to spend £1,000 or £1,500 getting an expert in, is it? But the higher value disputes, obviously you greatly put your mind at rest if you got an expert in, and because he could make or break your case depending upon what he says, because it's very difficult sometimes to say whether or not something has been done negligently or not. But I rarely see experts involved before issue of proceedings. Usually it occurs much later, but that's not to say you shouldn't try, because the system wants you to settle without issuing proceedings, to mediate, negotiate, agree perhaps with your opponent, invite him to agree to an expert before proceedings have been issued. You might flush him out, see whether he's serious or not about his proposed defence. And it will also make you look very good when it comes to the issue of costs. You'll say, look, I tried to get this settled. I tried to agree an independent expert with my opponent. They refused. The judge frowns and starts to think, I'm going to punish this opponent on costs. So finally, to come on to losses, I think if it was meeting a litigant in person here and they were talking about a building dispute, I would almost say, get out a bit of paper and write down, find a quiet corner of a house where no one's going to disturb you, put on some restful classical music, and just go through quite a neutral, independent way every item of damage and loss. And you might be surprised. For example, I've dealt with a few cases like this where damage has been caused. There's an agreement that the works will be done by a certain date and they're not, and you're then being unable to let the property on the rental market. Yeah. Now, rental losses could often be substantially larger than the claim value. Let's say there's been damage done to the kitchen units don't work or some electrical fault. You can't expect a tenant to move in, and in those circumstances, you probably can't expect a tenant to move in even where there's the place hasn't been properly decorated. So you should be very alive to those types of losses. Just get out that bit of paper and just think about what the losses there are that have been caused to you. You may have had to do some of the repairs yourself. Nothing wrong with putting in your claim form, I had to take a week off of work in order to completely, regrout the tiling in the bathroom. You may be an amateur builder yourself. Put down a low basic hourly rate for people in the trade and put it into your claim form. The judge can only knock it out at the end of the day, but at least claim for it. And again, go to the local estate agents, ask whether or not this property would be quite easily let on the property market, get a letter from them and get a valuation from the rental yield. Again, put that in your particulars of claim. Beefing up your losses in whichever way you can is a very intelligent tactical step to take in civil litigation, but don't be crazy about it. A lot of claims that I see, particular smaller consumer claims, claim for emotional loss and sleepless nights, and they were so distraught they kicked the cat and had to take it to the vet and it cost them £250. Emotional distress has to be, psychiatric damage virtually for you to get a court to side with you, at least in civil litigation. Claims might be different in employment tribunals. So don't load up your particulars with emotional loss type damages. By all means, if you've been forced to move out of your property and because it's simply uninhabitable until the works have been completed, well, include in those particulars of claim the costs to you personally of having to rent alternative accommodation for yourself and your family, and even let's say it's a completely different part of the city and it costs you an extra £50 a month to take the children to school. That is a loss that's been caused by the damage, so you can claim that too. Okay, understood? Finally, here's an issue that occurs very regularly, and that is where you're thinking, do I just move on with the repair works or do I wait? And proceedings can take many months, could take a year, could take 18 months, even in a fast-track claim. You may be running into a winter period. On the one hand, you want the expert at some point to come in and do a report. On the other hand, you obviously want to repair the damage and complete the job as quickly as possible. This is a judgment call. In one case, I encourage the clients to put off doing the work themselves because at the heart of the case, the defendant building company had alleged that they'd been told to leave the site and that they would have continued the work anyway if they'd been allowed to. So where at the heart of the dispute there might be an issue like that, you kind of do want to leave it as long as possible. Of course, if it comes to it, try and get the other side to agree an expert to come in early doors, or if they refuse, at least get your own expert to come in so that they can then complete the works. If that's not practicable, it's not the end of the day. Obviously, just make sure you take lots of photographs of all the damage that can then subsequently be produced at court. And for a lower value claim, an expert might be a bit exorbitant. So, by the same token, I had another client last month. She was like, "What do I do? I can't live in this house. We really need to get going on the works." in that case, because the defendant basically ignored her, it was clearly a building company that was looking at going into liquidation. She'd done a lot of photography work. She got a lot of evidence as to the damage that was done, and in fact it was very obvious that it had been a complete cock-up. In that case, I just said, look, write to the other side, tell them this is what you're going to do, that you've given them an opportunity to complete the works, and they haven't accepted that. They haven't taken you up on that offer. Get the works done. It's, at the end of the day, it's not fatal to your claim. So there it is. As you can see, building disputes can be a lot bigger than you at first imagined. There is a special pre-action protocol that applies in more complex, larger value claims, but it's no harm in reading that pre-action protocol. You'll find that just by Googling it and putting CPR afterwards, just so that there is a greater emphasis in these type of disputes to try and resolve things and to get all your soldiers in a row before you issue proceedings. Costs follow from all of that, so if you do rush into a building dispute too quickly and issue proceedings too quickly, you could find yourself in trouble on costs. Itemise the losses. Remember, offers are very important, and you need to be very super accurate in your offers. And as I said at the beginning of the vlog, do a little bit of investigative work into the opponent, because if it is a limited company, if you can't get around and sue the individual, and that's a sort of complex area where you might need a hit of legal advice, just a sort of fixed fee type legal advice on that one issue. It's just simply better to move on with your life and basically bite the bullet, because at the end of the day, civil litigation is a commercial endeavour, and you have to weigh the risks with the rewards. Okay, hope that's been of assistance. Bye for now.